So good evening. I'd like to call to order the Town of Farragut Board of Zoning Appeals meeting for March 27th, 2019. The chair recognizes that there's two items on the agenda for this evening. Number one being the approval of minutes, and number two being a public hearing on a request for variance. Has all of the board members had a chance to read through the minutes
Yes,
of
sir.
the previous meeting? And so in that light, do I have a motion?
I move to approve the minutes as they stand.
Second.
We have approved and second. All in favor, say aye.
Aye.
Aye. Any opposed? So minutes passed as written. With respect to the second item on the agenda, it's a public hearing on a request for variance from the building and total lot coverage requirements as applied to lot 54R-1, 11270 Matthews Cove Lane, .279 acres, zoned R1/OSR. Thomas G. Johnson, the third applicant. For all those that are here that are going to speak to this matter, would you please rise and raise your right hand?
Never hurts.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. So in these matters, typically our format is the town will speak to their input and their their view of the situation, and then once the town has completed that, then we'll have the applicant come in and respond, and if you want to ask any questions of the town at that point. I do want to clarify, there was a lot of information given, and some was given at the beginning of this meeting, and so I think it prudent with respect to this information that was provided by the applicant to ask the town to start, because I think it impacts the whole discussion. Have you had a chance to read what they presented this evening, Mr. Shipley?
I have not really read all of it. I did talk through the points with the council, so I'm pretty familiar with what they're talking about there.
So I think the first question that, prior to looking at the variance, this information provides a scenario if the town agrees to the logic used and the definitions used that would render a variance as not being required. And so I think we should start with asking the town, if you've had a chance to review this, would you so stipulate the town agrees or is in disagreement?
Yeah, I've not really had a chance to review it to that degree, because I just received it near 5 o'clock today, so honestly I haven't really had a chance to review that. Though I did talk the general point of most of this. I did talk with the applicant's attorney about that earlier in the week.
So with that being said, there's information presented here that if agreed to by the town would not require a hearing for variance by this board. Should we table this variance until the town has had a chance to review this?
Or should we ask the applicants if they want to give the town time to digest this late submission, and if the town doesn't agree with what's stipulated in here, then we go with the variance next month. Simply
Well,
because it just,
yeah,
to let you know, it's hard to make a decision based on evidence
Yeah.
we just got before the meeting. And
It is.
we spent a lot of time preparing, reading the information, which has been fantastic, by the way, absolutely fantastic. And I know myself, it's hard for me to digest. I'm not an attorney, so I'm trying to digest this information as quickly as possible, and I want to give a fair assessment to what you're presenting, so.
I understand exactly what you're saying. I'm Brian Sellers. I'm the attorney for the Johnsons, and this is something that as we continued to look at the zoning ordinance and speak with Mr. Shipley, it became apparent that, well, if we're being held to definitions in the zoning ordinance, so is the town. And so looking at the language, seeing at least an ambiguity, if not a complete defense to the allegation that we had exceeded the coverage requirements, we put forth this argument. I did speak with Mr. Shipley on Monday about it, not in the detail that's presented in the supplemental memorandum today. And I felt like, in fairness, that it was something that needed to be presented to the board and to Mr. Shipley to look at. If the board feels like we need to put this off, I understand completely, but the Johnsons are anxious to get this resolved one way or the other, and if there's a way we can proceed tonight, that would be helpful. If not, you're going to have to reschedule a trip or something.
Correct.
Okay. At the
I
next
don't really
meeting.
want that for y'all either.
So, Mr. Shipley, my understanding of the logic laid out in this new document is based on the definitions of dwelling unit versus lot, and the number of dwelling units that were constructed at the time that the applicant's property was constructed would change the amount of square footage requirements to where this would be within the appropriate allotment. And there's a challenge there that I think the town needs to answer that question, whether you would agree with the logic that's laid out in this paper and how this is
I
decided.
think probably the cleanest thing to do, if we're going to take that route, and I hate to, put it off, but it wasn't really advertised for that type of relief, and we just received that information late in the day. This appears to be more of a questioning of an interpretation of a section of, in this case, the zoning ordinance, but we really didn't advertise it for that. I would not agree that, I do agree that what's provided is the language in the ordinance as it's written. It's not how it's been applied in the OSR zoning district in any other development. And frankly, to apply it in the way they're talking about would be very difficult, because you essentially would have to adjust that number every time someone built on a lot, because it would keep changing all the time. And then again, people are not being treated equally, because the first person to build in the subdivision could basically consume their entire lot if you took that logic. So clearly the intent of the language was to base it on the number of platted house lots, not the number of dwelling units that are in the development. Is that some language that needs to be clarified with a text amendment? I would agree it does, but it's not how it's been applied as far as how they're arguing it.
Well, maybe we could go ahead and discuss the variance as presented in the materials that we reviewed before the meeting, and can we set this aside and maybe
Yeah, we can. Yeah, that's fine.
this is, because this is certainly still something that maybe can be addressed later, but I was prepared to hear about the materials that was presented to me before the meeting, and so maybe we could continue with that discussion and see how that goes.
Okay.
So just to clarify on this new information, you would need to get a review by town council to look at that, to render a final decision. Who would be the,
Well, again, it's, I would not feel comfortable making a decision at this point based on that. I know what they're asserting here is not how we have
Correct.
applied it in the OSR to every other development that's been constructed as OSR. It's like a lot of language you find in ordinances in all communities. There's some language that, we find out later might need to be clarified, because it's really, frankly, never been an issue as far as that particular interpretation
Correct.
or language and how it's been applied.
so I would ask the applicants, I think at this point, if, as Mr. Meyer has expressed, do you want to move forward tonight with the variance, or would you prefer to get the town to respond to this information? I don't know how quickly that could happen, and we could table this variance pending that decision by the town on agreement to, or disagreement in the reasoning for that with the information that was presented this evening.
Right. I'll have to consult with my clients briefly if that's okay.
Sure, that's
I would
perfectly
like to
fair.
say, just, general, There is obviously case law in Tennessee that a zoning ordinance is to be applied with some deference toward the property owner, that although it's supposed to be consistent with the general purposes of the zoning ordinance, it must be, any ambiguity will be resolved in favor of the property owner's rights to unrestricted use of his or her property. And since zoning ordinances are in the nature of derogation of common law, they're to be strictly construed. So the language is what the language is. And if there's any ambiguity, it's construed in favor of the property owner, and the town would have to comply with that. I understand completely what he's saying.
Sure.
It's not the way it's been applied, but it is the way it's written.
And I think the intent of this board, and you guys correct me if I'm wrong, we're not charged with having to interpret consistent application of zoning requirements. It's more of just listening to an argument and determining whether a variance is warranted.
Right.
Based on our authority only. So I'm not sure actually a conversation about interpretation of,
Sure.
of zoning ordinance is actually within our
At this point.
authority
Right.
of BZ, of just this board itself. But
Okay.
I can throw that out to my peers on the board to see if you see a different.
I think it could be if it were
Okay.
advertised as such.
Correct.
My concern is it wasn't advertised for that kind of
Right.
relief question.
When you say advertise,
So-
we have an obligation to.
And it
Give
wasn't
public notice on what
intentionally
the
not
intent of this
advertised
hearing
for
is.
that. I
That's-
just didn't.
Let me speak with the Johnsons then for a moment, if you would
Sure,
mind.
take all the time you need, please, yes.
And as a, well, okay, I guess I better wait.
Yeah, let them decide what they want to do.
As a point of order, we don't need to wait another month though, do we? I mean, we could do this, next week.
Well, no, you have to have a certain advertisement.
Every one of our meetings.
Yeah, BZA has to have an advertisement in the paper a week before the meeting, actually.
A week before the meeting.
Has to appear in the paper a week
Yeah.
before.
So that would be next Thursday, so the earliest we could have it would be 2 weeks from tomorrow.
Potentially, that probably would be the earliest.
I mean, I'm just saying that may make it a little easier rather than waiting another month.
Yeah.
Well, I'll wait for them to come back to ask my question about. I guess, Mark, I can ask you whether if the applicant so stipulates they'd like the variance held, the hearing held this evening, does the town have any problems with us holding that discussion on the variance and making a decision either way prior to the town reviewing this other information?
They could always apply, they could always request a review in a different,
But-
format.
All right, we'll call to order again. And I forgot to say, Mr. Sellers, at the beginning, if you could please just state your full name and your address for the
Sure.
record. And anyone that is speaking, please use the podium, and we would need your full name and address.
Right. My name is E. Brian Sellers. I'm an attorney with Winchester Sellers, Foster and Steele. It's a law firm in Knoxville, 800 South Gay Street, Suite 1000, Knoxville, Tennessee, 37929. I'm also a resident of Farragut,
All right, thank you.
11649 South Monticello Drive.
All right, thank you very much. And so before we had taken our break, we had been discussing this new information, and so I know you had some time to confer with your clients, and
I did, and I think we discussed that as an economy of effort, we believe that it's probably best to table this for the time being, let the town consider it. We do have some questions or conditions that we would like to see. Obviously, there's a temporary CO that's been issued that will expire before the next meeting, so we would need that extended.
Yeah, that's fine. We can do that.
The Johnsons are also under some pressure from the HOA to get their landscaping done, and they're trying to get in as quickly as possible. One of the questions they had for me was if the town between now and the next meeting agrees with our position, would they acknowledge that and withdraw that before that meeting comes up, or do we have to advertise it and go through the whole process?
So I would think that if the town stipulates to this, there is no requirement for a variance at that point. If the town agreed with the arguments and the logic presented in the documents this evening, there would be no call for variance based on the numbers I see. And I can't speak to those numbers. Obviously, the planning division would need to go through and look at all of that and make sure it's still in compliance. And if that's the case, there's no need for a variance or to come back. If there is a disagreement with the town or they don't stipulate to that, then we would need to be here to hear the variance as it was originally posed to us. And I guess the question is, we would just need to table this then, and it would be on the agenda unless it's removed for the next meeting, Mark, is that
Well,
correct?
I'll, obviously talk with the town attorney about the town's position. I mean, this could become a, one of the things that the board does have the authority to consider is, it's here under section C, 1. It has the power to hear and decide appeals where it is alleged there is an error in any order, requirements, decision, or determination made by an administrative official in carrying out any provision of this or other zoning ordinances enacted by the Board of Mayor and Aldermen of the town of Farragut. That's, I think, what they're requesting. And at this point, they are alleging that we are not applying the provision as it's written. And that's something I'll just have to talk with the town attorney about. Obviously, as I stated earlier, the way that we have applied it in every other OSR district is based on the number of platted house lots, because that's obviously the intent of the language to do that in the district, because it is unmanageable if you do it the way that they're talking about. So depending on what the town attorney says, we may have to advertise it as an appeal of a decision made by a town staff official, and then have it heard in that regard, potentially.
Okay. And so for this evening, we should just table the current item we have on the agenda.
That's what they're requesting. They have to request that. They would need to request the hearing as it's advertised as a variance, and then I'll have a discussion with the town attorney as to how we want to proceed from our perspective.
All right. Obviously, we're not waiving any of the other things that have already been advertised. If there's if what we've put forward isn't manageable, and if there's a reason why it can't be applied the way we've asserted, we still think that there are grounds for a variance, and the circumstances of the matter and how everything came about. So we would request that it be tabled for the consideration by the town, preserving all our rights to assert the right to a variance, and then the interpretation that we're talking about.
So do you need a motion from us to do that, or is his request?
It would be better to go ahead and just take action on their request and formally table it.
Sorry?
So we move to table. I move to table the request for a variance, item number 2 on the agenda tonight, until further notice.
Okay.
Have a second?
Second.
All in favor?
Aye.
Any opposed? Moves forward. And seeing that there are no other agenda items, do I have a motion to close the meeting?
So moved. Second.
All in favor? Aye.
Aye.
Opposed? Meeting is adjourned.